What I want to do in this lesson is move on to the next major topic in the subject of the criminal law. We're going to be talking about specific criminal offences for the next few weeks and months, focusing first on the various different homicide offences that exist. Now, we're going to only spend one lesson essentially on each of these offences because they're relatively easy to understand and they're relatively non-controversial in the way in which the law is applied. We'll begin in this lesson by talking about murder, and then we'll move on to the various different varieties of manslaughter which exist in the next few lessons. So, homicide offences is something that we're going to outline as well in this lesson, essentially what it means to commit a homicide and the sort of class of offences which exists. So in answering that question then, sometimes people like to conflate the idea of homicide with the idea of murder. This is a false comparison. They are not the same thing. And the reason why they're not the same thing is because homicide is a more general classification. It refers simply to the killing of an individual. This may be lawful or unlawful, and it could be murder, but it could also be other kinds of unlawful activities. And by lawful and unlawful, there are circumstances where the killing of another individual, i.e. the committing of homicide, is actually lawful. For example, in the context of an armed conflict, when shooting against a lawful combatant. This is something of this would be a lawful means of committing homicide. In terms of unlawful, there are other kinds of unlawful activities which could be considered homicide which are not murder. For example, things like manslaughter, things like genocide, things like assisting suicide. These are all examples of homicide-related acts which are not the same as murder, but which are still unlawful. So murder specifically refers to an actual the killing of another individual with what is known as malice aforethought. So we're going to get to Lord Coke's actual definition of murder in a second, but what should be noted is that there is no murder act. There is no statute on the books that is outlines very clearly what murder is and what murder isn't. Instead, murder is a common law offence. And this means that it is not specifically attached to a statute or statutory provision. And so the result of which is we get the definition first elucidated by Sir Edward Coke in the 17th century. And ultimately, this definition is fundamentally a definition of murder which still applies to this day. The language has been updated and we've sort of made various different changes to how it is described in modern parlance. But in terms of the key components and in terms of the key elements of murder, they are all present in the 17th century definition as cited by Sir Edward Coke. So ultimately, the definition of murder is cited as follows from 1797. It says the following. It says that murder is when a man of sound memory and age and the age of discretion, unlawfully killeth within any country of the realm any reasonable creature in reum natura under the king's peace, with malice aforethought, either expressed by the party or implied by law, so as the party wounded or hurt, etc., die of the wound or hurt, etc., within a year and a day after the same. So some parts of this definition are, as you can probably understand, pretty redundant in terms of the language and in terms of the elements that are required. But there are elements of this definition which is very, very, very much applicable to today's modern understanding. Age of discretion, of course, means the age at which criminal liability arises. A man of sound memory, of course, rules out the idea of a defence of diminished responsibility and or defence of insanity. The idea of a reasonable creature refers to a natural person, which again obviously is controversial in some circumstances. Under the King's Peace refers to the idea that we shouldn't be prosecuting individuals for murder in wartime, and this obviously falls into the concept of lawful homicide under the killing of a lawful combatant in an armed conflict. And then the concept of malice aforethought, either expressed by the party or implied by law, relates to the mens rea of the offence of murder. So all of these things are elements which are still required, and they give us both an actus reus and mens rea of the offence. The actus reus for murder is relatively easy to understand. If we look back at the Koch definition, we can find the actus reus elements. We see that the defendant will cause the victim, a reasonable creature, i.e. a person, to die, to killeth. This is done under the King's Peace, again excluding the lawful killing of individuals during an armed conflict. When it comes to the mens rea of the offence, again, equally in the Koch definition, we can find the mens rea. The traditional language is to kill with, quote, malice aforethought. Today, this is essentially translated to an intention to kill or to cause grievous bodily harm. So, when somebody commits murder, it doesn't necessarily have to be a requirement that the individual wanted to actually kill, to end that person's life. You can be convicted of murder if you intend to cause grievous bodily harm to an individual, but in doing so, you resultantly murder them as a result. You end up killing them as a result. Let's begin to talk about some of the cases then that illustrate some of these points. In 1985, we have the case of Crown versus Maloney. In this case, we see a stepfather and a stepson, Maloney, and they had a very close relationship with each other, and they decided to both enter into a shooting contest, looking to see who could draw their guns quicker. Now, they did so while they were drunk, so obviously probably not wise suggestion to do so even sober, never mind while you're drunk. In doing so, the stepfather was accidentally shot and killed. The questions that we have to ask, therefore, is whether or not the actions by the defendant was an intention to kill or to cause grievous bodily harm to his father-in-law. Given the fact that this was a shooting contest looking to see not who can shoot each other, but who can draw their guns quicker, we can come to a conclusion that it's probably the case that they were not intending to kill or cause grievous bodily harm, as a result of which their murder conviction was overturned and reduced to that of manslaughter. The House of Lords would also clarify the issue of intent when it comes to the criminal law. They say that in order for a person to be convicted of murder, they must have an intent to kill or to cause grievous bodily harm. The Lords also made the argument that foresight of the consequences in and of themselves without a direct intention may not be sufficient for a conviction of murder. So even if you had some reasonable foresight that one of the consequences of the events that is taking place is the death of another individual, the killing of another individual, if that still exists without the prerequisite intention to kill or cause grievous bodily harm, then this means that it still is not sufficient in and of itself for a conviction of murder. It was also made clear that the key consideration here should be the defendant's purpose and whether there was an intention to bring about a specific result which would give rise to criminal liability. So a good way of showing or trying to show intent to kill or cause grievous bodily harm is seeing what the specific result which was ultimately intended to have been achieved actually was. If the specific result was the death of a victim or the severe injury of a victim which would constitute grievous bodily harm, then this can be sufficient for showing an intent to kill or cause grievous bodily harm. In the case of Maloney, however, this wasn't the intent. There was never an intent on the part of the parties to actually kill each other. They were trying to see who could draw their guns quicker, and owing to their general negligence and owing also into their general drunkenness, they were unfortunately in a situation where one would kill the other. In 1975, we also have the case of Hyam and the Director of Public Prosecution. The defendant in this case was in a relationship with a man. When this relationship ended, the defendant became increasingly jealous of her ex's new partner and fiancé. She would then pour petrol into her new partner's letterbox and light it on fire, set it on fire. The resulting fire would end up getting out of control, killing the new partner's 2 young children in the house. The defendant was then tried for murder. Now, the issues here was the question of whether or not Dee could be convicted of murder, since she did not have an intent to kill the 2 children when performing said act. Well, the jury could convict for murder, but the House of Lords would uphold the conviction, should I say. Now, why is that the case? Given to the fact that it may not have been the case that the individual in question had the intent to kill the two young children, why was it the case that the House of Lords still upheld the conviction? Well, the jury could convict of murder, and the House of Lords would uphold the conviction. They would uphold the conviction for a number of reasons, all hinging on whether or not the defendant knew or not the probability, should I say, that the children were in the house at the time of the act. And it was that foresight, which, as stated previously, was not in and of itself sufficient, but still very much a key consideration that was important for making a determination as to the guilt of the defendant in this case. The case of Crown versus Woolin from 1999 also illustrates another example. You see, in a fit of rage in this case, the defendant would kill his 3-month-old son by throwing him into a hard surface. At trial, the judge directed the jury to convict if they were in the mind, or of the mind, that D realised the, quote, substantial risk in the action which was committed by the defendant. It was held that the conviction was to be reduced to manslaughter. The reason for this was this idea of substantial risk. It was incorrect for the trial judge to direct the jury by suggesting that the standard was a standard of, quote, whether or not there was a substantial risk and whether or not the defendant realised there was a substantial risk. Because what this does in taking the ordinary language of the phrase substantial risk is confuse the concept of intention with the concept of recklessness. And in doing so, you are confusing the concept of murder with the concept of manslaughter. And so one of the key delineations between murder and manslaughter is a delineation between intent and recklessness. And so as a result of which, having a conviction of murder for a jury direction which would be better suited in the context of manslaughter is one that essentially confuses the situation. The jury must instead ask 3 questions relating to the issue at hand. The first question being, is the result for which criminal liability exists one which was virtually certain, a certain consequence of the actions of the defendant? The second question is, did the defendant know that his actions would be virtually certain as a consequence of, virtually certain consequence, should I say? And then finally, the last question is, given the evidence, would the jury be satisfied with finding the intent of the defendant? Finally, then, I want to talk about the concept of coincidence or coincidence of mens rea and actus reus, because it's not just enough that you have to satisfy both the actus reus and the mens rea of an offence, but it is also the case that they have to coincide with one another. In most cases of the criminal law, the concept of murder will require a coincidence of the actus reus and the mens rea. It doesn't mean that they have to occur at the exact same time, but just that there is a continual act that is taking place such that this coincidence is satisfied. Now, one of the challenges to this is the case of Thabo Mailey from 1954. In this case, the defendant had intended to kill the victim by hitting them on the head, and had done so. They had hit them on the head with the intent to kill them. In fact, what had actually happened was that they hadn't killed them by hitting them on the head, but they had only knocked them out. Now, when the defendant had then rolled the victim off a cliff, the defendant believed that at the time the victim was dead, because he believed that by hitting him on the head he had killed him. It was only then that the victim would actually die from his injuries and exposure at the bottom of said cliff. Now, the argument that was presented by the defendant here is that there could not be a conviction of murder since there wasn't a coincidence of actus reus and mens rea. At the time of the attack, at the time of actually hitting the victim on the head, there was the prerequisite mens rea for murder because the defendant had intended to kill the victim, but there wasn't the actus reus because in doing so, the victim hadn't actually died. But then when the victim did eventually die, owing to exposure and injuries from falling off the cliff, there was the actus reus, but there was no mens rea at the time. And so arguably it is the case that there was a lack of coincidence, which would result in a lack of murder charge. It was held, however, that this argument would be rejected, suggesting that you cannot divide a case like this up into a separate series of acts. Instead, what actually happened was the entire series of events in their entirety represented one continuing act, allowing for the prerequisite coincidence of actus reus with the mens rea of the offence. Welcome back, everybody, to Criminal Law. In this video, what we're going to do is move on from looking at the first of the major homicide offences that exists in English criminal law and start to talk about the next of these homicide offences, specifically the crime of manslaughter. Now, manslaughter is a little bit more complicated than the crime of murder because there are various different kinds of manslaughter and different ways in which manslaughter may or may not be justified. And so, as a result of this, we're going to spend quite a few lessons talking about manslaughter in more detail. We will be focusing in this lesson on the concept of voluntary manslaughter, the first kind of manslaughter, and the first method by which you can show voluntary manslaughter. This is by way of diminished responsibility. We'll talk about a number of cases involving diminished responsibility in that regard. So, voluntary manslaughter. The idea behind voluntary manslaughter pertains to an individual who will have the mens rea and actus reus for the crime of murder. So they have all of the prerequisite requirements to show that they have, in fact, murdered an individual. But their liability will be limited in a number of different ways. And in this case, when you talk about voluntary manslaughter, their liability is limited by the fact that they are able to satisfy a partial defense to the murder charges. And so when there is a partial defense, and it is there are a number of different ways in which you can justify partial defense when looking at voluntary manslaughter, one of which is, of course, diminished responsibility, which we'll get to in a second. This doesn't absolve the individual of any liability. It is not a full defense for the crime that is committed. Instead, it is a partial defense, which limits the liability. It takes liability from murder all the way down to manslaughter. Now, the rationale for having this kind of system in place relates to the statutory requirements that exist in relation to sentencing. So when it comes to sentencing that a judge has to do when it comes to murder cases, there is a mandatory life sentence. This is a minimum for a murder case. So at the very, very least, an individual who is found guilty of murder will have to serve a life sentence as a minimum. However, when it comes to cases of voluntary manslaughter, or manslaughter more generally, the concept of a life sentence isn't the minimum, it is the maximum that is placed on the defendant. And so as a result of this, by being able to essentially satisfy a partial defense, either through things like loss of control or even through diminished responsibility, which is going to be the topic of this lesson, what the defendant is able to do, or at least what the judge is able to do, is have a certain amount of discretion in relation to sentencing. Because if it was murder and they were found guilty of murder, there is nothing a judge can do other than a mandatory life sentence. Now, there are mitigating there are mitigating circumstances, essentially, to maybe adjust the sentence itself, but it would still have to be a life sentence. In addition to this, when we talk about the case of manslaughter, a life sentence is possible for a manslaughter case, but it can only ever be the maximum sentence that exists. So we can show voluntary manslaughter, i.e. where we have a number of different elements that could relate to the crime of murder, but liability is limited by the fact that we have a partial defense through one of three defenses. You have diminished responsibility, which is the subject of this lesson. You have loss of control, which will be the subject of the next lesson. And you also have the idea of voluntary manslaughter through something known as a suicide pact. We're not going to spend much, if any, time looking at the third of these because it's a very niche reference. If you want us to go through and look at this in more detail, then leave a comment down below. But for now, at least, the structure of these lessons won't include the latter of these three. Because for the most part, you only really have to know about diminished responsibility and loss of control. So let's think about diminished responsibility, what it means and how it actually works. the concept of diminished responsibility is actually outlined and defined in statute, specifically Section 52 of the Coroners and Justice Act of 2009. What Section 52 says is the following. It says that a person, D, the defendant, who kills or is party to the killing of another is not to be convicted of murder if the defendant was suffering from an abnormality of mental functioning, which arose from a recognized medical condition, substantially impairs the defendant's ability to do one or more of the things mentioned in subsection A, 1A should I say, and finally provides an explanation for the defendant's acts and omissions in doing or being party to the killing. This is what diminished responsibility tells us. Essentially, it is a type of defense which relates to the abnormality of mental functioning. Now, it's not necessarily the defense of insanity, because the defense of insanity is more of a full defense rather than diminished responsibility, which is a partial defense. So it is an abnormality of mental functioning. There are certain requirements that have to be provided. You have to have a recognized medical condition. In a lot of cases involving medical conditions, or mental conditions, should I say, and psychiatric conditions, it has to be recognized. So if we're talking about and shifting over into the civil law, we look at the law of tort, for example, psychiatric harm as the result of negligent action has to be recognized psychiatric conditions. Similarly, in the case of criminal law and diminished responsibility, there is a requirement that it is a recognized medical condition. There has to be a substantial impairment on the part of the defendant and their ability to do one or more of the things which are mentioned in subsection A. We'll get to that in a second, as we've cited here. And then the final part is that given both of these factors, the action itself, or the medical condition itself, mental condition, has to provide an explanation for the defendant's acts or omissions. So the things that are mentioned in subsection A are as follows. 1A, should I say, are as follows. Those things are to understand the nature of the defendant's conduct, to form a rational judgment, to exercise self-control, and then finally 1B says that for the purposes of subsection 1C, i.e. providing an explanation for the defendant's acts or omissions, an abnormality of mental functioning provides an explanation for the defendant's conduct if it causes or is a significantly contributory factor in causing the defendant to carry out that conduct. So the recognized medical condition has to substantially impair the defendant's ability to either understand the nature of their own conduct in the killing or being party to killing, to form a rational judgment when it comes to decisions relating to killing another individual, or to exercise self-control. This is what diminished responsibility tells us, and how we structure the defense of diminished responsibility to reduce liability from that of murder to that of manslaughter. So from this, one can derive the concept as having a number of factors which contribute to the partial defense. We have to have an abnormality functioning of our mental state, essentially, which is caused by a recognized medical condition. This abnormality must be a significant factor, contributing factor to the actions of the defendant, and the abnormality must have impaired the defendant in the ways that are specified, i.e. in Part 1A of the provision. Let's look at some case law then, at how this has actually been applied by the courts. So in the case of Crown versus Dowds in 2012, we see that the defendant had stabbed a victim, the victim in question, 60 times, causing, as you'd imagine, the victim to die. Not many people are stabbed 60 times and lived. And so as a result of which you have the question of murder, and then the question of whether or not we can satisfy this partial defence. The defendant claimed he was entitled to the partial defence of diminished responsibility, owing to the fact that he was in fact acutely drunk. And it was held that this was not a satisfactory condition for diminished responsibility, and so the murder conviction was upheld. For the purpose of Section 52, the concept of a recognised medical condition does not include voluntary intoxication. It does not satisfy that particular requirement. In 2017, we have the case of the Crown versus Conroy. In this case, we have a defendant who had both autism spectrum disorder as well as ADHD, attention deficit hyperactivity disorder. And he spent a lot of time in care and had essentially developed, as a result of these disorders, very violent and sexualized behavior. While living in care, he would form an obsession with another resident who he then intended to have sex with against her will, intended to commit sexual offences against. He would strangle her and try to ensure that she was unconscious, but accidentally instead killed her in the process. And so the question, therefore, is raised about charging this individual with murder and then thinking about diminished responsibility as a partial defense owing to both the autism spectrum disorder and the ADHD, and whether or not these are recognized conditions and whether they impaired the defendant's ability to make rational decisions and to have self-control. While he was convicted of murder, it was recognized that autism spectrum disorder and ADHD were recognized medical conditions for the purpose of diminished responsibility. So this case is actually quite important for recognizing both ADHD and autism as conditions which can form and be part of this general overall spectrum of diminished responsibility instances where we can have a medical condition that is recognized. The question for the jury, which would ultimately lead to the conviction, was not whether or not autism spectrum disorder or attention deficit hyperactivity disorder were recognized medical conditions, but rather whether or not, given that they were, whether or not this was something that impaired the defendant's ability to form a rational judgment, which is, of course, the next step when you think about trying to show diminished responsibility under Section 52 of the Coroners and Justice Act. So the issue here is whether or not the defendant is substantially impaired at the time the act was committed. It can't just be the case that the defendant has committed murder, or should I say has killed an individual, okay, he's alleged to have committed murder, and that they also have a recognized medical condition. Those two things just being on their own does not mean that you can satisfy diminished responsibility. It has to be shown that A, they have a recognized medical condition, and it was this medical condition that led to them being impaired at the time the act was being committed. And they define what substantial impairment essentially means when we look at 1A, subsection 1A of Section 52. Now, the way in which this operates in practice is that this is a question which is left to the jury on the basis of the evidence presented. So this is not necessarily a legal question, it's a factual question. And the case of R versus Gold from 2016 is interesting in looking at this particular analysis. Following an argument that was had, the defendant would attack his partner with a knife, resulting in her to be killed, resulting in her death. It was argued at trial that the defendant himself had a history of mental illness, which was supported by multiple pieces of witness testimony. So the evidence was given that this defendant had a lot of different instances of mental illness, and the issue that was had here was whether or not the defendant had been suffering from this psychotic condition, these mental illnesses, at the time of the stabbing, and therefore would satisfy the requirement for diminished responsibility, and then therefore have this partial defense. Because ultimately, if an individual is charged with murder, and if an individual, like in this case, attacks his partner with a knife, causing her to die, the individual can't just raise the question of whether or not they have a mental illness and say that's enough to satisfy diminished responsibility. They have to show that the mental illness was clearly and substantially impairing the defendant's ability to make rational judgments and have self-control at the time at which the knife was used and at the time at which the attack happened. So it was in defining the term substantial in this question was taken to mean having some substance, okay? And they went on to suggest that what having some substance meant was, quote, anything more than merely trivial. Again, not particularly helpful, but giving us some more ideas as to how we recognized psychiatric illnesses, but also how these psychiatric illnesses actually impact decisions that are made. And so when we talk about what is substantial, as in what is having a substantial impairment on the defendant's ability to have logical thought and to have self-control, is anything that is more than merely trivial. It has to be a significant factor in the establishment of whether or not it was caused by this medical condition. Now, in 2017, we have the case of Crown versus Blackman. This is actually a very interesting case because it actually originally began as a murder case and went through the court-martial as a murder case, but then eventually changes to a diminished responsibility case. So it's a very famous case, the Marine A case, for any of you who studies international law. The famous case of Sergeant Alexander Blackman, Marine A, who was a Royal Marine who was caught on camera executing a Taliban insurgent in Afghanistan. When this happens, when a clear violation of the Geneva Conventions is not only reported, but is also actually caught on camera, then you have murder cases. It becomes a murder trial when the particular soldier in question gets court-martialed. In the video, he is heard making derogatory claims to the insurgents. He says a number of different things, clearly showing, at least on account of the evidence, that he was acting in a way which was particularly hostile to this Taliban insurgents. I believe he said something along the lines of "off from this mortal coil" as he shoots the Taliban insurgent. And then he also follows this up by informing his fellow Marines that he, quote, just violated the Geneva Convention. The first crime, in my opinion, is that he said Geneva Convention, not Geneva Conventions. There's more than one. But more than this, at the court-martial, it was originally held that he was convicted of murder. He would be convicted of murder as a result of this particular action. However, it was overturned and substituted for manslaughter by way of diminished responsibility. And the reason why this was the case is because evidence came to light that Sergeant Blackman had been diagnosed with or argued to have been impaired by an adjustment disorder, which had not been considered by the courts at previous point. And then at this point, when the charge was overturned and reduced to manslaughter, he was then let out on the basis of time served. Finally, then, let's think about the case of the Crown versus Joyce from 2017. The defendant in this case was a paranoid schizophrenic, which is, for all accounts, a valid medical condition which can be utilized as part of this partial defense. And what he had done is had been taking drugs and then went into a shop, took a knife out, and killed one of the fellow customers. It was held that it was decided that he was able to claim on diminished responsibility on the basis that the recognized medical condition not only existed, he was a paranoid schizophrenic. Schizophrenia is a recognized medical condition for this purpose, but it also represented the, quote, main and significant factor in impairing his mental fortitude. This adds a little bit more to the question of, when we take the medical condition, how can we show, and what basis of evidence can we show that the medical condition was the major cause, major representation of the as a factor which causes the lack of mental fortitude, which leads to the decision to kill another individual. In this case, it was held that because the paranoid schizophrenia represented a, quote, main and significant factor in contributing to his lack of mental fortitude, this therefore satisfies the requirement for diminished responsibility.